Good morning, hello friends, my dear students. Welcome to Legal Matters by Shankar Sai Babu. I am very happy that yesterday about 178 people liked the video. That is a Teachers' Day. It's not my speech, Teachers' Day special. But anyway, it's a good response from all of you. Today, we are going to discuss a case, a decision given by the Honorable Supreme Court of India regarding the witnesses who in our view they are called as interested witnesses. Normally you may be knowing while submitting the arguments we say that so and so witnesses they are related to the deceased, they are related to the prosecution witness, therefore their evidence may not be taken into consideration, it may be discarded because it is interested witness, because they are related, definitely they will speak in support of the prosecution, like that we will be submitting. But in some cases, particularly the cases of dowry death, who else will come and hear the evidence? Who else will come and see the occurrence? Normally, suppose if it's a murder, when somebody is murdered near Rangarayadu tank and by a rowdy, and if some person while passing that way, if he sees, definitely he will come to the court and give evidence that he has seen it. But within the premises of the house, if something happens, normally the inmates of the house, the relatives, they have to only speak. So you cannot discard their statement, but their statement should be weighed or should be viewed with higher caution. This is what is held by the Honorable Supreme Court of India while disposing the case of Guman Singh, Gumansinh, alias Laho, alias Raju Bhikkhubai Chauhan versus State of Gujarat, 2021. This decision came by the Supreme Court on 3rd September 2021. You can see it in LL Live Law 2021 SC page number 415. Right? Friends, remember this relates to crime number 92 by 98 under section 498A and 306 IPC read with 114 IPC. This is in Vadodara court, that is in Gujarat state. Alright, so coming to the brief facts, the accused, this Guman Singh Bhai, he married the deceased Tahera on 27/4/1997. They are a below poverty line family, very poor people. Of course, after she joined the maternal house, yes, she was doing the daily course and she is attending to the cooking also. But what happened is after her coming to the matrimonial house, then the accused started harassing her to bring additional dowry of 25,000 from her parental house. What for? In order to purchase some cattle and do milk business. So please remember, his harassment is for that. So he harassed her to get 25,000 from her house. But they are financially very, very poor. She could not inform the parents to get the money. So when she did not inform the parents, the mother-in-law also started castigating her that she doesn't know how to cook, she doesn't know how to do the household works or chores, all these things. So she was subjected to harassment and this man used to beat her. Ultimately, unable to bear the harassment, within 8 months, that is on 14/12/1997, she committed suicide. This is briefly the case. So a case about registered, he was arrested and his mother, all these people, they were sent, the charge sheet was also filed. The lower court, so taking into consideration of the evidence of the so-called relatives of the deceased, relatives of the accused also, because all of them are interconnected. Ultimately, they were satisfied so that the case was proved beyond against any reasonable doubt, and therefore the trial court convicted these persons for 1 year and fine rupees 500. Right? Agreed by this, they approached the Honorable High Court of Gujarat at Patna, Gujarat, and the Gujarat court also, I think in 2018, they have dismissed the appeal. That means they held the trial court version. The punishment is sufficient. After all, 1 year and 500 is nothing. But anyway, they are not aggrieved. They are aggrieved. So ultimately, the aggrieved party approached the Supreme Court also. So now the case has come before the two judges bench, Sri Justice Abdul Nazir and Krishna Murari. Right? Please remember, the Supreme Court held that the evidentiary value of close relatives cannot be rejected since they are relatives. The victim, definitely, the victim normally she reveals or she discloses the information to the relatives, particularly regarding the cruelty, because it happens within the four walls or boundaries of a ball. So only thing is, court has to be cautious while weighing the evidence of the interested witnesses. Definitely, if there are any infirmities, definitely you should give the benefit of doubt to the accused. This is what the Supreme Court held. In so many cases also it has come. But normally we say that since they are interested witnesses, their evidence cannot be. So the advocate on behalf of the accused, that is appellants, he says that the witnesses are close relatives and interested witnesses, and no independent evidence was taken, no independent witness was examined to prove the case. So prosecution evidence is doubtful. But Supreme Court held like this. Ultimately, the Supreme Court based on three principles, they have also dismissed the appeal. That means they held that the conviction given by the trial court is 100% correct. So the points, the conditions laid by the Supreme Court is that the woman should commit suicide. So she should meet with other than natural death. Number two, such a suicide should be within 7 years from the date of her marriage. Here it happened just within 8 months. Third point, the accused should have subjected to cruelty. Yes, here there is very clear evidence that she was subjected to cruelty. So therefore, if these three conditions are fulfilled, the presumption can be drawn against the accused. If he could not revert the same. Very good judgment in favor of the prosecution. Of course, sometimes we have to take into consideration of these judgments also. Very good judgment. Please read it and enrich your legal knowledge. Thank you very much.